LAProbate expert. This is our weekly probate call. We do probateweekly.com every Thursday, 4 p.m. Pacific and 7 p.m. Eastern Time. And saying Eastern Time is important today because our special guest is not only in Eastern Time, but is generously making himself available to us at 7 p.m. Eastern Time, and we appreciate that. We do this every week, and I will tell you is the more you participate, the more money you make, more income and wealth you create. And so anytime if you have questions, put them in the chat box or raise your hand in the Zoom call. We want it to be interactive. We're going to probably mute most people just because we have so many people, and I believe this is the largest probate weekly real estate call in the United States. We have had over 100 people the last couple of weeks. Really excited to see the growth and appreciate all your support. We do live stream this onto YouTube and Facebook. It's recorded there as well. So if you miss it, feel free to watch it on recording, like, subscribe, ask questions. And if you're watching the live stream, you can ask questions, and I'll be monitoring the live stream as well to see if you're there. If you have a question, we'll try to pass them on as well to keep you involved. But again, it's meant to be interactive. This is for investors, wholesalers, real estate agents, vendors, attorneys, and petitioners. We've had all those people on in the last few weeks. And the idea is to get together and share best practices and good vendors and good practices so we can all have better results. So it's really all about giving. I don't really have anything to sell. I don't have a coaching company. I don't have any data that I sell. I'm a real estate broker, and if you're in LA or anywhere in Southern California, I can help you with a probate sale. Feel free to reach out to me in the social medias. Really lucky today to have a special guest. I often get asked to bring in experts and to bring in attorneys to talk about probate and related topics. And so today, I'm really lucky to have not just a probate attorney, but a very active one who's referred by a friend of mine, as well as coming to the state of Florida to give from the state of Florida to give us a little different perspective. So please say hi, give a warm welcome to Jamy Barreau, attorney, probate attorney in the state of Florida. Hey, Jamy. And you're muted. Let's see here. Sorry about that. There you go.
All right. Oh, yeah. Hi, Bill. Thanks for having me.
Fantastic. Thanks for joining us today. So give me a little background if you can before we get started. We know you're an attorney because it says so on the internet. It must be true. But where'd you grow up? How'd you get into law? And then what brought you to probate in particular?
Well, I grew up in Port St. Lucie, Florida. And really, I got an interest in the law at a young age. So my family, they come from Haiti. And I learned that my grandfather did serve as a judge, primarily in the family law realm in Haiti. And that was my inspiration to go into the law. And come to find out, taking a few introductory classes in high school, turns out I love the law. So it just worked from there.
Fantastic. Let me get myself back on here. So you grew up in South Florida and you practice, and do you practice exclusively Florida or would you practice other states as well?
So I exclusively, for the time being, practice only in Florida. And my practice areas do include probate administration, estate planning, and very recently, my firms opened up their doors to Medicaid planning, VA planning, and special needs planning. Fantastic.
So Barreau Legal is the name of the company in Florida. And so one of the reasons I like to interview attorneys is real estate agents, investors mistakenly think that attorneys do everything because some advertise they do everything. And they also need to look for certain patterns, I think, of success and specialization. You'll see some combinations. And so on the front of his website, he has estate planning, trust administration, probate administration, Medicaid planning, business planning, and evictions. To some degree, they're all kind of related. What's not there, I don't see, is litigation, probate litigation. So if by chance it ends up in a litigation, is that something you refer to somebody else, or do you just not advertise for that? Or how does the probate litigation piece fit for you?
Correct. So the litigating a probate matter, you'll see different rules used. So although I understand the rules, I just don't work with them day in and day out. They're not my specialty. So when those come along, I refer it to a trusted colleague who I know will do a good job for you.
Good. And obviously, you'd be a great source to go to for those referrals. You would know who does a good job. But I think it's important, my experience is the attorneys that make really good estate planners and administrators often, no offense, don't make great litigators. They're a different personality type, different business practice, really. I think your whole business is set up differently, in my experience. And so when I see that, I feel very comfortable that we're talking to somebody who specializes in one area and does a good job. So let's go one by one. Let's talk about, since it's your first one listed, estate planning. Talk to me a little bit about what's a common client for an estate planning case that you deal with.
So at my firm, I like to tackle everything from a generational wealth standpoint, right? So making sure that you can pass on not just what you've accumulated, but really set on the next generation and next after that with success moving forward. So typically I have clients who lately I've been dealing with clients who are younger, who really are starting out, whether that be starting out their businesses or starting out their careers, starting out their families. And really, they just want to make sure that they can either protect their assets during their lifetime or even protect them for generations in terms of their children, if they have minor children and things of that sort.
So when people ask me about estate planning, I usually say to them, listen, at some point, you're either going to be incapacitated or going to leave. And either you have a plan or the state of California has a plan for you. The state of California plan really starts, it looks a lot like the Department of Motor Vehicles, standing in line, filling out forms, and getting the high personal touch service that California DMV is known for. Is that the same in Florida? I mean, Florida's a great state. I used to live there. I'd love to move back. That's a intention with me and my wife. Don't want to get into all that right now. But is Florida's same way that if you don't plan, Florida has a plan for you and it's not as, say, effective as what you might set up?
That is absolutely correct. So I would happily reiterate what you're saying. If you don't have a plan, the state of Florida will have a plan for you. In fact, we have a saying that we like to say, no plan is a plan for failure, right? Mm-hmm. So if you have no plan, you're planning on being failed. So think of it this way. If you have think of it as if you had built your assets for your entire life. You have family members and friends that you're close to, and you have some that you may not be so close to. And, the state of Florida does not take into account, your friendships or how close you were with, or how far you were with maybe an estranged loved one. It's pretty black and white who inherits after you if you don't have a proper estate plan.
Now, also, estate planning also can have a big impact if you're still alive, but perhaps not, don't have capacity, whether that mean you're in a coma or you're temporarily unavailable for whatever reasons. So people often overlook that, but man, when you get in that situation, I had a client who became incapacitated and he had a bunch of properties, and you create a conservatorship. I don't know what it's like in Florida, but that's done in probate court in California, and then the attorneys wanted to create a trust to put the conservatorship into the trust, and then they left out a couple properties by accident, and then it gets sold. It was a whole thing. So it's the same case. Estate planning also takes into account what happens if you don't leave, but aren't ready to go yet, kind of in the midstream. You're medically incapacitated. Is that covered in the estate plan process as well?
So it absolutely is, and I'm glad you mentioned that, because a lot of people think, well, why do I have to come up with an estate plan? I don't really own much. But it's more than just taking care of your estate. It's taking care of your person, right? Your life, right? So if you do become incapacitated, we do have measures like a durable power of attorney to step in and make sure somebody can take care of your affairs. Same with healthcare surrogate designations, designation of preneed guardian. And again, you fall back to the same thing. If you don't have a plan, the state of Florida has a plan for you. So over there in California, I heard you mention there's conservatorship. Here, it's called guardianship. And, any interested person in Florida law can petition to be an incapacitated person's guardian. And that's whether or not you really personally trust or want that person to take over that role. So it's very important to take that into consideration when you're planning out not just your estate, but just for your life.
My daughter recently had our first grandchild. My daughter is married to her son-in-law, and we're blessed. Thank you. And they live nearby. We spend a lot of time with them. But then the question comes, well, what happens if something happens to my daughter and son-in-law, God forbid? Who raises the child? You say, well, we get along. My wife and I get along, and my daughter's in-laws and we get along. Well, that's all great. We all get along until we don't.
That's right.
And I think my wife and I have enough difficulty in our household raising kids. And then you add in two more people in New York, whereas in an estate plan, you would determine who the person was in charge of raising children and things like that, right? Is that part of the process?
Correct. You would not only just for yourself, but your children, your assets. But I want to make one thing clear, at least in the state of Florida, right? You saying that on a sheet of paper, let's say I have a 3-year-old child and I name my cousin Philip to serve as the guardian of the child. Well, that's a nomination, right? It still has to be presented to the court, and the court has to make a determination on whether or not Philip can legally take on that role. So that's why it's also important to plan these sort of things out with the trusted ear of an estate planning attorney, because
Right.
under Florida law, if we're talking in the context of guardian of an adult of myself, if I'm trying to name one, you can't be committed, you can't have been convicted of a felony. You must be over the age of 18. You have to be a blood relative unless you're a Florida resident. These are types of things that you won't generally think of when you're in the planning process, unless you have somebody who understands the law on your side.
Yeah, what I tell people is having a will or directions that aren't properly executed is like going to DMV and there's two lines. There's one for with the form and one without the form, but you still got to go to DMV. You got to wait in line and wait for them to decide what to do. And so I like the way you say that you can have the nomination, but the court has to empower that person to have the force of law. Otherwise, it's just a piece of paper until it happens. So let's talk about trust administration. A lot of people avoid problems, but it's not really avoiding problems. It might be minimize problems or attempt to avoid problems by putting things in a trust. That's part of it. But at some point, the trust has to do something. It has to sell the property, it has to distribute funds. So describe, what does trust administration look like?
So trust administration, it really looks like basically following whatever terms whoever we call them, the testator, whoever created the trust, following whatever rules they left behind. Now, without a trust, generally speaking, your property, your assets will have to pass through the probate process. But with a trust, it passes outside. The general thought behind that is if everything you own is in a trust, you own nothing at the time of your death. The trust does. So really, it's just following the terms of the trust and also making sure that any other aspects of the law are taken into account. So some states require that certain bills are paid through the trust, final expenses, stuff like that. It could empower the trustee to hold on to the assets for a certain amount of time, or it could require the trustee to distribute assets right away. So really, it's really following the rules that the trustee left behind within the bounds of the law.
I had a recent experience where, what does that mean though? Like, for example, there's distributing assets, but there's also like getting documents so that you can prepare tax returns, right? The decedent passes, somebody has to file their tax return. There's taxes owed before, and then there's a trust account, perhaps tax record required as well. Is that part of the trust administration? Do you delegate that out, hire accountants? How do you handle the paperwork and the administrative process of the trust?
So that is correct. You will have to deal with the decedent's last tax returns, and in many cases, you're going to have to deal with multiple years of tax returns if the decedent failed to keep up with your taxes over the years. And depending on the size of the estate, you may have to deal with estate tax concerns as well. Depending on the law firm, as my firm in particular, although I do have a little bit of a background in tax, specifically with estate tax, I outsource any income tax issues to CPAs. So it's really good during that time to build up a good team to tackle all of the necessary points of the estate.
So if the CPA comes back to you and says, well, we need a 1099 from Bank of America, Chase, Citicorp, Schwab, or whatever, do they get that? Do you get that? Does somebody pay to do that? How does that, in a trust administration, how do those administrative details get handled?
So it's going to depend generally firm to firm, but generally what I've seen in my experience and what my firm would do is I would take on that mantle and say, okay, well, we're administering, we're going to gather up all of the necessary tax documents that we can, because especially if the trust is worded properly, that trustee is going to be empowered to do a lot, to have a lot of authority, to get a lot of documentation. Absent that, a probate would need to be open. A personal representative would have to be appointed in order to carry out those tasks, which is why good planning ahead of time with a strong trust document is very important.
These are the same fundamentals. It's interesting, the laws, I'm sure, are different, procedures are somewhat different, but the fundamentals are just the exact same as we have here in California. So the third leg, if you will, of your business, of your practice, is probate administration. So probate administration, from what I've seen, is similar to trust administration, with the main difference being the trust was kind of planned for, and almost by definition, the probate wasn't really planned for. And it feels like you're more scrambling for resources, you're scrambling for getting things done kind of afterwards. Is that kind of a fair summary, or what does probate administration look like from your business point of view?
So I think that is a fair assessment, but also a lot of people need to understand that even if you do have a will, at least in the state of Florida, I think in some states it's different, perhaps in Texas, but that's neither here nor there, not my specialty. But at least in the state of Florida, having a will does not avoid the probate process. It acts more so as a roadmap for the court to make that final determination as to where assets will go. So if you don't have a will, then things could be very messy, right? You leave doors open for family members to contest. You leave room for discretion for the court to make certain determinations when it comes to personal representatives and of the sort. So really, it's going to vary, but having somebody who's experienced with the processes of probate makes a world of difference.
Now, you said something that I think is really important, and so it's true in Florida, I think, as well as California. Whether you have a will doesn't change if you go to probate court. It just becomes one piece of the puzzle that the court looks at to determine what happens in probate court, correct?
Correct, yes. Yeah.
And I think in some cases it can even be worse to have a will in that it gives objectors, in some cases, something to point to argue about, to muddle up, versus no will. But the will certainly, in California, and it sounds like Florida, does not avoid probate. I think that's the number one misconception people have.
Correct. It does not avoid probate. And it's funny you mentioned the will causing more troubles. Me personally, I prefer to have a will because everything's black and white, everything's thorough, laid out for the court. But I have seen instances where it wasn't properly notarized, or it didn't have the proper signatures, or perhaps it forgot to mention how a certain asset is to be distributed, or maybe there's a typo. So there could be a lot of issues that, sometimes I sit back and I say, wow, if I didn't have a will, we wouldn't have this issue right now. But the key is, I always recommend have a will, but make sure you have it done by a professional who has the experience to know, because what I like to think of the will is, it's almost like, I call it a roadmap, but really it's an investment. It's an investment to save time and effort during the probate process.
One of my favorite movies of all time, probably because I was dating at the time my girlfriend, now my wife of 36 years, was Body Heat. I don't know if you saw it, but it took place in the state of Florida. It was all about a case of a will and signatures and witnesses or not, and some twists and turns in the movie. I don't want to be the spoiler, but certainly, again, sometimes the will can be, if done properly, is always better to have than not have. But if done improperly, can create more problems than if you didn't have a will. And so I would say, if you find a will before you rush to court, you might want to talk to an attorney and have them look at it and just make sure it protects the interests that you think are important to you. Okay, so a couple good questions here, if I could, while we're on probate, which is, and it's interesting, Probate court in California includes probates, trusts, guardianships, conservatorships, a number of different issues. I think of it more as real estate with problems that get solved in court, but as opposed, maybe excluding family law, but it is a broad topic we're walking down today. Katie asks, what are the fees for probate administration and estate planning with a will or without a will? Now, obviously, they vary, Katie, based on who you go to. There's, like everything in life, there's McDonald's and there's fancy restaurants with fancy hamburgers. They're all hamburgers, but they're different experiences. But Jimmy, in your case as a practice, how do you handle that question? I'm sure people, when you enter, ask the question, what's it going to cost to do a proper estate plan? And I have a probate to administer or file. What's the cost for that? How do you answer those questions?
So, as a lawyer, I fall back as always, it depends, right? But really, it truly will depend on what firm you go to and the circumstances within your own estate. My firm in particular, I only charge flat fees. I think it's easier for me, easier for my clients. In terms of estate planning, depending on your assets, it could be really, it could be a range in terms of the fees for that, right? But when you're looking at the fees or at whatever attorney you're meeting with, you need to understand that you may be paying a few $1,000s now, but think of all of the money you will save for your loved ones down the line. Because a probate administration, depending on the facts, depending on how heated it could get, I've seen it reach, $15,000, $20,000, and the issue hadn't even been resolved yet, right? So it really, but with proper estate planning, you could avoid probate altogether and minimize your risk of losing a lot of money to the courts, to lawyers, in fights. And now there's another piece too that you got to think of too when you look at probate is the hard costs, the fees to the courts. I think it varies from county to county, and I think in my particular county, St. Lucie County, the fees just to file with the court is somewhere around, I want to say $350 to $400 or so, just to file the court and get your day in court with the judge. So these are all things that you need to think about when you're making that initial investment in your estate plan.
Yeah, I can tell you as a real estate agent, I see bad real estate agents cost their estates lots of money. One is by dragging out the process. Probates are kind of like having family guests. The longer it's around, the stinkier it starts to get, the more problems you have. And the longer you're in process, the more hard feelings, the one family member, if there's multiple family members, will say, well, gee, the house should sell for twice as much. I saw it on Zillow. And next thing you know, they're hiring an attorney, there's an objection, and everybody's spending money on legal fees they don't have to. So clearly, getting a professional who can quarterback you through the process is always more valuable. Evelyn asked a question. So the answer is it depends. I'm sorry, just finish up there. And in your case, Jamie, they go to, if they wanted to ask that question, they would go to your website and fill out a contact form. And also I see on the top of your page is a phone number. So I guess you could call, they could ask the question. They can give you the details of their case and you can give them an estimate at that time as what the fees are, right?
Exactly. And I hold free consultations. So I'm always happy to chat with folks. And we can see, if my firm's a good fit for you and really what that type of representation would look like.
And that's why I have them here. I did it, we've spoken previously and we talked a little bit. And the only reason I'm going to bring somebody on board is as a resource to you guys. So feel free to give them a call. And that's why we're here. Some attorneys don't offer that. They want you to pay up front. They want you to make an appointment, come in their office. And so if you go to his website, which is blegalfl.com, we'll put the chat notes. Top left corner is a phone number. And then it's also a form if you want to set up an appointment. So another great question from Evelyn. Does every property go to probate? Or for properties in a trust, does it still have to go to probate? So just keep putting a property in a trust to avoid probate is their question, I guess.
Right. And that's an excellent question. So if it's in the trust, properly in the trust, then it will avoid probate. It will not have to go to probate. But be careful, because I've seen folks in the past create a trust and they list in the trust that they want their property in there. but you need to understand what it is, what it means to properly fund your trust, right? So having it listed in a trust isn't enough. In the state of Florida, for instance, if you'd like to put a property in a trust, you have to record a proper deed, an appropriately worded deed. Bank accounts need to be retitled in the name of the trust, and it has to have the specific verbiage needed to do that. So, but to answer your question, yes, a trust is a tool to avoid probate of your property, and there are other tools too. And your estate planning attorney can walk you through what those tools would look like and if it's better for your situation.
Again, as a real estate agent, so many times people make a trust and never, as you say, title the property into the trust, or they take it out to refinance for some reason, don't put it back in the trust. So in California, we have a process. On one hand, it sounds simple, called a Hexet petition, where you can go to the court and say, hey, this property should have been in the trust, but here's the reason why it's not. And the court may allow them to make that title distinction. Is there a similar process in Florida?
So yes, there is. Generally speaking, there are several causes of action that you could bring to the court to try to remedy, issues that might have come up. But I think with proper planning, you could avoid that
Of course.
altogether.
Of course.
Absolutely.
And the other thing about California, it's a simpler thing. It's just this one form called the Hexted form, but anybody can object to it, so it gets dragged out. In LA County today, if you file for a petition for probate, you get a hearing in 30 days. Theoretically, you can be authorized. But a Hexet petition hearing is at least 6 months today in the court. So it's a simpler process, but it takes 6 months and costs more than a probate might cost. And certainly costs more than a reasonable estate plan would cost. So Jamie's point is right on that a properly documented estate plan and documents with the deeds will avoid all those kinds of issues. Another one now, I'm not familiar with how this works in California. Should you put your homestead in the living trust? I'm not sure what that means. Does that mean the house you live in, your residence, and you have a homestead exemption on it? And does that go in the living trust? Is that what that, I imagine that's what that means.
Right. So and that's what I'm assuming from a Florida standpoint. So yes, in Florida, we do have our homestead protections, meaning that you cannot have the property taken from you, in some exceptions though, but and also you do get some tax breaks as well for owning your homestead property. And under Florida law, you can transfer your home to a revocable living trust, which will maintain at least some of your homestead protections, namely that homestead tax bill. It will allow you to reap the benefits of that as well. So as long as it's a revocable living trust, meaning a trust that you are allowed to change and modify during your lifetime, yes, you can protect your homestead interest.
Great, thanks. She thanked you as well, or he. Okay, so let's go to the next area, which I think is very much related, or else I guess it wouldn't be in your business. But we don't have to talk about that in this call, which is Medicaid planning. So Medicaid planning, there's certain expenses in the process that might cause you to have to pay back out of the estate, medical expenses in the last part of your life. So can you describe a little bit about what Medicaid planning is and why that's so important as well?
So generally speaking, when you're trying to get a hold of Medicaid benefits from the government, you have to meet certain asset and income limits. Right now, generally speaking, if for a single individual, you can't have more than $2,000 worth of assets and around $2,300 or $2,500 in income off the top of my head. So what the federal statutes have allowed for is for you to take some of your assets and move them and retitle them and move them in certain ways so that you can qualify for Medicaid. One of those ways is transferring your assets to an irrevocable trust, meaning it's out of your ownership. You cannot, change the terms of the trust. You cannot move those assets around. But at the end of the day, those assets aren't in your name anymore, and it helps you to qualify for Medicaid benefits. And it's just because Medicaid is a needs-based, at least long-term care is a needs-based program.
that you're theoretically paying into as a taxpayer along the way. Just to go back real quick, a question from Katie. She keeps hearing that when a person passes away in Florida, their debt goes with them. Is that true? Now, in California, it's definitely not true that your estate's liable for your debts. In fact, the debtors get paid the creditors get paid before the heirs do. That's part of the reason of probate is to protect the state gets paid, taxes get paid, probate court gets paid, attorneys get paid, creditors get paid. Then any money left over goes to heirs. What's it like in Florida when somebody passes? Do any of the debts get wiped out, or are they still all there waiting for payment?
So, Bill, I'm glad you phrased it the way that you did. And I'm going to say that it depends, right? Because probate is in Florida the last stop for creditors to get paid. They have a certain amount of time based on a notice. Generally speaking, it's 3 months, but it can be cut down to 30 days with techniques. But after that time, those creditors who fail to step forward, they're not going to get paid simply, generally speaking. But I like to think of it, I like to explain mortgages in particular when I speak about these things, right? So suppose mom passed away with her home and there was a mortgage on it. And the children inherit that home. In Florida, mortgages aren't a typical debt that's dealt with in the probate process. The children inherit that home. And then, yes, the kids own the house, but they still have to deal with the debt. They're not responsible for the debt unless they signed and agreed with mom to pay the mortgage. But the consequence of not paying that is what? Foreclosure, right? So when a child does inherit a home with a mortgage on it, it's best to deal with it, whether or not to assume the mortgage payments or to refinance, pay it off somehow. So generally speaking, I would say to an extent, debt does die with the estate. But Bill, you're right. In Florida, you do have to deal with that in the probate.
So somebody on Facebook asks, I think one of my favorite questions, just because it catches people by surprise. He asks, it goes back a little bit to where we were talking about probate and wills. Why is probate required if a will is in place?
So that's an excellent question, right? So from the scholarly point in me, right? Probate is the process by which you pass assets of a deceased person. So when you have a will only covers assets that you own during your lifetime, or I should say at the time of your death. So really, the will doesn't move assets. It doesn't technically direct things to go anywhere. It's more of an instruction manual. So you still need to go to the probate process because a dead person effectively owns property, and we don't want that. That's not very efficient for our society. So it still will have to go to the probate, still has to go to the judge, but now the judge has a playbook, a roadmap, which is the will.
Yeah, I think that's the number one. And I mentioned it previously as being a misconception. I think that's the number one misconception is that a will in and of itself avoids probate. And the answer, again, I'm not an attorney, but I can say this with conviction. It doesn't, because I've been in probate court a million times and seen the probate and I know the code. And that's why you have to plan ahead. Now, a will can do certain things. And if all he needs covered in the will, that's great. But it needs to go to probate court to be effectuated. Okay, Joanne, who's a knowledgeable and a regular member here, says that the attorney filed the deed and didn't have the full property description, and the homeowner or heirs were unaware of the discrepancy. What happens to the home? Is this a Hegstead? So this is a common thing. Now she's asking in California because she's a California agent and Jamie's an attorney in Florida. So in Florida law, if the attorney did file the deed, but it had a mistake in the description, what effect does that have when it's time to transfer? Let's say it gets caught, the estate goes to sell the house, and then they catch, hey, the deed's wrong. It says 123 Main Street, and it's 124 Main Street. or an obvious typo. 123 Main Street is 123 Maid Street. What happens in those cases in Florida law?
So generally speaking, what you're looking at there is you're getting closer to a real estate, a property law issue. And what I've seen happen in those cases is a real estate attorney. I would recommend a real estate attorney to come in and file probably something along the lines of a quiet title action to try to rectify the issue that was there. I know there are some Florida laws that might assist in those situations, but generally speaking, you run the risk, if it wasn't done properly, you run the risk of that transfer being deemed ineffective.
Yeah, the one thing I caution attorneys regularly is not that sure about the law, but to some degree, it doesn't matter what the law says. If I can't transfer title and get title insurance, then it doesn't really matter if you're right about the law. And there's certain types of cases, like commonly in California, in a probate case, you may not need to file a notice of proposed action if the only heir is petitioner. There's nobody to notice, maybe other than creditors. And by law, you don't require a notice of proposed action. However, the title company won't insure title. It doesn't matter how right you are legally. If the title company doesn't insure title, we're not going to close escrow. And by the time you understand that, you're going to have to file the notice of proposed action. Your buyer has problems with the rates and things. Who knows what happens? So, and this is a case too, where when the deed's wrong, it depends. Another circumstance, Jamie, would be, well, the deed doesn't matter unless somebody makes an issue of it, right? Maybe it's, I have a case where it's the name Joe Smith, and there's a son, Joe Smith Jr., and the question is, who wrote the deed? And the father had passed, and Joe Smith Jr. stopped using Jr. when his father passed. So who signed the deed? And what effect in law does it have? Well, when was it signed? And and of course, it only is an issue if somebody objects and makes an issue of it. Then it doesn't matter if you're right. Now you've got to hire an attorney and go to court and prove you're right. So, Joanne, really, those are great questions, and Jamie gives some great answers. But at the end of the day, it depends on what you're trying to do and who can help you get it done. And probably that's either a real estate attorney. I'd be glad to look at that one with you, Joanne, see if I can help. But it depends what you're trying to accomplish. So good luck with that one. Okay. Another question. Great question. You guys are doing great. There we go. Okay. So here's a question for Arizona law, just to add it up a little bit. I had a couple weeks ago an Arizona attorney on. I just dealt with this in King, Arizona. My father's trust had an APN with an extra number. I've seen this happen many times. The trust shows the property and the county doesn't. This, I think, and Joanne's question, I think, is similar. This isn't really a legal question. What you're saying is the deed says one thing, but when I go to look at the title company's report, as a realtor, we get access to public record data. They scraped it and they're saying a certain thing. They're saying it's still in the name of the individual or trust. It doesn't matter what the title company says it says. It matters what the document says and what the title company will accept. And so generally what I tell them is, if you're ready to do something, get the actual documents, take them to the title company, have them look at it, and they'll tell you what they'll insure or not. And the truth is, even if it's not legal, if the title company insures it, that's not your concern, right? Your job is to get your client what they want. If they don't need to hire an attorney and they can sell the property and they get title insurance to get insured clear title, that's not a legal question. That's just a business question. And I see that regularly. I do see regularly typos, mistakes. And the APN really is just for convenience. It's really the legal description that has to be done properly, I think, at the end of the day. I think, I don't know what's like in Florida. In California, we have a deed that has a legal description. They'll say also known as 123 Main Street, and they'll put the APN. But really, the APN is just for the assessor when they file it for their convenience, but doesn't really have any legal standing, correct? Or how does it work in Florida?
That one, I would actually defer that to a real estate attorney, to be honest. Yeah.
But at the end of the day, the judge accepts it. You don't care, right? The judge orders the transfer of the property. Doesn't matter what the deed said. The judge in California, the judge signs the document. You're good to go, right?
Right. Yeah. And who knows? Later on, I've seen creative attorneys come back to contest it later on. But
exactly.
You're right. If the judge is happy, everybody's happy, right?
Exactly. Okay. Next question. If at the end of the day, it's always if the judge will sign it, it doesn't really matter what you say. You can say what the law is till you're blue in the face, but if the judge approves it, you're done pretty much.
That's a really good point. I like to tell my clients all the time, I can study the law, I can give you an analysis, but at the end of the day, you never know what a judge is going to say. Um, it's their courtroom, and they have the last say.
Yeah, it's really the old days. I'm older than most people call, and my father was an attorney in LA County Superior Court. And when you went to court, there were days my dad took me to court. I imagine my mother needed a day off, and whatever, it took me to court just to babysit me or something. But you went to court in a suit and tie as a guest. These days you can tell the attorneys they're dressed formally, and everybody else is in shorts and a t-shirt or jeans. But in the day, like literally, I remember seeing signs on the door. If you're not wearing, if you're wearing tank tops, you weren't allowed. If you're wearing this, you're not allowed. That it was very formal. But the power of the judge still exists. The judge can just say yes or no and sign it, and you have a court order. You can pretty much take that to the bank. Question from iPhone. If somebody dies and they have a trust with two named heirs, what happens if one heir dies? Do the assets go to the remaining heir, or do the deceased heir's portion go to the spouse and or children? So I'm going to guess the answer is depends what the trust says. Usually a well-written trust will assume some of these situations and will be written away to react to the situations, and a poorly written trust won't. But Jamy, you're the professional here, so what's the right answer?
So I would agree with you. It depends on what the trust says. Under Florida law, the default is, I'm going to throw some Latin out at you. Property is inherited per stirpes. So that really looks like, so in this scenario, let's say that the beneficiaries are brother and sister, and brother died first. With the legal theory of per stirpes, in that situation, brother, if he had any children, well, his children will take his share. If he didn't have any children, then his siblings would take his share. So it basically, it'll pass, by the line of succession under Florida law.
Famous case in California was Howard Hughes, and he didn't have any children, and his siblings didn't have children. His siblings did have children, but they're like 160 cousins, and they all split up his assets. That's why some of his assets were split up and sold. Question I have is on a trust, though, it may not be known. I mean, to go back to trust administration, I think the best practice is only the trustee has the trust and the attorney. You don't give a copy out to everybody to proofread or double check your mistakes. So really, oftentimes I get phone calls from people who say, I know my father left this to all of us, but my brother, the bad guy, he's a trustee. He says it's just to him, and he's selling the property. He's doing this or that. So is there any protection in that case if he is, in fact, the trustee based on the documents, and he has proof of it? Does anybody ever look inside the trust to see that they're structuring it properly, or what protections are there?
So the way that Florida law works, right, is that if you are a beneficiary of a trust, and this is, we're assuming that the trustor, the settlor, the person who created the trust has passed away, you have a right to receive a copy of that trust, right? So the trustee can't withhold that from you. Now, if you get into a situation where the trustee isn't providing you with that, that's where, you'll get an attorney involved to come petition the court to force the trustee to either turn it over or, present their defense, something along the lines of, oh, well, this person isn't a beneficiary to this trust. So at the end of the day, if you suspect a trustee isn't doing what they're supposed to be doing, there are safeguards in place in terms of going to court and getting a judge to mandate that everything go how it's supposed to. But, unfortunately, in many cases, turns out, maybe the trustor, the settlor, changed their mind and changed their trust before they died. So that could have been something in place, but there's still safeguards nevertheless.
And so just so I understand, so it might be that they don't show a copy of the trust to the non-beneficiary, but they might have to show it to the court to prove who the beneficiaries are based on the trust.
Correct. They'll either have to present it to the court or present whatever defense or argument that they have at that time.
Got it. Oh, that's interesting. I didn't really know. Another question I'm going to ask, just because I get to ask this one a lot, is deed in the trust, mom and dad passed, nobody can find the trust. What do we do now?
So I had a colleague that was grappling with that a while back, and it may depend. It may depend. You might have to go to court. You might be able to just proceed, but it's going to take, I think that one you're going to have to take a moment to look to see what your local laws are saying.
Yeah, it's going to vary by state for sure. And again, it depends you can, by right, have the right to sell the property, but the title company won't accept it. It doesn't matter what your rights are. You can't effectuate those rights, or you have limited. Okay, in Florida, what happens if a married husband passes away, warranty deed states a married man and doesn't state the wife's name, who's listed with a mortgage on with the husband? This is complicated. Will the wife be transferred ownership, or will no will, or with no will become a life estate? So with married husband, he passed away. There's a warranty deed that says he's a married man, but didn't say the name of the wife. Okay, so I'm Bill Gross, married man. I own the property as my sole and separate, but the mortgage has the wife on it. So does the wife get property? Does it transfer automatically? Imagine if in California it would transfer automatically to a spouse. In Florida, does it transfer automatically to a spouse?
So in Florida, in that situation, no, it won't transfer automatically, right? So if husband died and he's the only named person on title, his estate is going to have to be probated, and you will have to go to court to get his interest transferred. Now, if it's just husband and wife, then wife will inherit the entire property under Florida law. However, if husband had children from outside of the marriage, you may be looking at an instance where the wife is only receiving either a life estate, or she could elect to take a 1/2 interest in the property and share the rest of the property with her stepchildren. So if you're in that situation, I would recommend speak with an attorney so that you can get that navigated and processed appropriately.
Yeah, that one. Anytime you have multiple potential objectors, you better get an attorney up front, because if you don't, my experience is they're going to object later on. You're going to end up paying for it, and you probably didn't start with the right game plan in mind. Property owned by two parties, dad and son, and the home is homesteaded in dad's name only. When the home is sold, it's considered investment income for the son. That's a tax question, I would think, but and then you're talking about so the son is going to inherit the price. So I can say I believe that father passes, gives to son. You're inheriting it a stepped-up basis. So I would think the answer is no, but I don't know. What do you have any experience in that area or any particular?
No, I would agree with you. If that's the fact scenario, there is a step up in basis, and as long as you're not selling it, as long as you're not selling it long down the line where the value has significantly increased since the time of death,
right,
you should be sheltered by that step up in basis.
That said, in the market we're in now, a year and a half, property's going up 15-20%. In California, on $1 million property, that could be some real money. So another reason why you want to get your probate closed as quick as possible, and rather than run the risk of paying for taxes that you don't otherwise have. Okay, so, some more good questions. This is from Joanna again. Joanna Jensen, different Joanna. Out of California, I'm not sure if that means it's in California or it means out of California. Successor trustee changes the trust after the trustor retires, but before they die. Well, normally that wouldn't happen. Normally the successor trustee wouldn't. It would be the trustee to do that. But assuming, I'm not sure why they'd be a successor trustee and the trustor hasn't passed yet. Putting the entire estate to only himself and his heirs, removing all other heirs from the trust while trying to, telling them that they were never in the trust. In fact, okay. So yeah, I see these kind of questions all the time. I'm sure you get these too, that, gee, I know I'm in the trust, but my brother took over and he changed this before my dad passed. And instead of splitting it 3 ways, it all goes to him and he's selling the house. And I think the answer on that is these cases are going to depend on the actual facts, the actual documents, and you need to get with an attorney to review that. And I would say try to pull the public record documents so when you go see the attorney, you have the facts and simplify the process to get to the point. But I hate to say that. I think, Joanna, I don't know if you agree, Jamie, but it just depends on the details that we don't have in this question, in the particulars, to give you a good answer. But the answer is going to sound like go see an attorney, right?
There you go. Exactly. And I would agree. It's going to be very fact specific.
Yeah. And then can you get a copy of the trust in the lawyer's office if you're a beneficiary? And again, I think you stated that you're entitled to a copy, but it doesn't mean they're going to give it to you.
That's right. And when you're dealing with attorneys, and especially with the different states and the different bar rules, even at death, we have a duty of confidentiality to our clients.
Right.
So it could be appropriate for us to pass it along, but also remember, not all attorneys are going to have a copy. Especially, I've noticed that a lot with the older firms. Some of them just don't hold on to those or even have the original. So I personally would think that would be a good first step to go and ask, but I wouldn't think that that's the end all be all.
It seems to me in Southern California, the general practice is for the attorney who prepares the trust not to keep a trust on purpose, on the assumption there might be multiple copies, changes after they walk out the door, and they make the client understand that this is important. You got to put it someplace safe and deal with it. But unlike in the old days, I think where attorneys held the wills for their clients, and I know my father's practice, that was part of their business practice. It seems to me that these days attorneys are careful, for the most part, not to keep anything for fear of creating confusion. And then oftentimes people say, well, you have a copy of the trust that you prepared, but it wasn't signed. Well, that's a whole nother pack of worms, right? Because who knows what that means. Was it changed? Did they ever execute that or not? So what's your practice as an attorney? Do you keep copies? Is that something you discuss with the client individually, or do you not keep copies of the documents?
So at the time being, my clients hold on to their original documents, but I keep electronic copies of the signed documents just in case.
Nice.
Because many times, you need the original document to probate a will. But if it's lost, if it's been destroyed, attorneys have a way of getting around that. And it really helps to at least have that electronic copy. So that's my practice at my firm.
Yeah, and that seems more common now, electronic. It's easier. You have a record, there's a date and a time stamp to where the document is, and it's gotten less expensive to store. And I know the companies have a service where they have documents and you share them with various people, the various parts, and there's a record of all that going on. So, okay, and Barrington asks, if a spouse passes away but both names are on title, is there a probate process needed? Meaning husband and wife are on title, but husband passes away, do you need title? In California, the answer is no. It would normally pass to the spouse, community property, if it was a joint tenant situation. Tenants in common, different. But generally speaking, it would normally pass. And if it's not specified in California, normally it just passes to the surviving spouse. How does it work in Florida?
So in Florida, when you have husband and wife on a deed, the presumption is that it's with right of survivorship. So once one spouse dies, by operation of law, the next spouse will take ownership. And generally speaking, in Florida, all you have to do is really record a death certificate, and that should signify the transfer.
Yeah, and I think that's the case in California. We get the death cert, we file that with the prior deed, and everything gets taken care of. Okay, well, look, this has been great. We've had a lot of great questions. I think we got through all of the questions I see in the chat box, and we're coming up on the end of our time. So let me just ask you, since we have a lot of real estate agents on the phone, and a lot of real estate agents make a business of working with attorneys, what would you say is a business practice for real estate agents to avoid when building their business and working with attorneys? And what's maybe one thing that you see them do that you think they should try to do or focus on?
I think, personally speaking, and I don't see it generally with realtors, from what I've seen, you guys are pretty professional. I mean, you handle things the way as you should.
Wow.
Maybe I've been lucky.
Thanks.
Maybe I've been lucky.
Maybe in Florida. Maybe that's part of it.
Yeah, maybe that's what maybe. But what I will say is, be careful not to tread into legal waters. Be careful not to run into the unlicensed practice of law. which I see and I have seen come across a few times in my career, because I don't know about California, but in Florida, it's a felony. So that's the biggest thing that I would say, in terms of it. So keep a good attorney in your back pocket, someone you trust, and for you to reach out to and spit ideas at with.
That's a great one. So avoid practicing law, and the good practice would be to get a good attorney that you work with. And I think that's too many times as realtors we think, or investors, we think we have to have relations with 20 or 30 attorneys, and the answer is one good one is worth more than 20 poor relationships. And so that's all said. Speaking of great relationships, Jamy, I sure appreciate your time with us today. We spoke previously. It's on my YouTube channel. But I know we even talk about kind of your motivation in this and how committed you are to helping families preserve wealth, to preserve generational wealth. And I focus all the time on estate planning because I feel as a realtor, it's just, we don't want to just focus on probate, you have to sell your house, but teach our clients avoid probate, get an estate plan, and build wealth and pass it on to your family. And then the customers will use you because you bring value to them in a positive setting rather than just there to pick over the bones at the end of the deal. And I know that's where you come from. So, Jamy, I really appreciate your being with us today. Jamy Barreau, again, the website is BLegal, B for Barreau, legal, FL for Florida.com, BLegalFL.com. We'll have the show notes as well. On the top, if you look at it, there's a phone number you can call, 772-236-5204. Again, 772-236-5204. If you go down below, you can fill out a contact us form with the details and questions and emails and such. And I just know it comes from the same place that I try to come from, which is being of service. So, Jamy, thank you so much for being with us today.
Thank you for having me.
And for all the people who asked great questions today, Joanne and so many of you, really appreciate your guys' participation in making it special. We do Probate Weekly every Thursday, 4 p.m. Pacific, 7 p.m. Eastern Time. We live stream it on YouTube and Facebook, as well as it's recorded on my YouTube channel. If you go to YouTube, Bill Gross EXP, you'll see past episodes, or you go to probateweeklyepisodes.com, you'll see the full playlist. Thank you for support. Feel free to like this, subscribe this, and look forward to seeing you next week.